Are we ready to get started? Good evening and welcome to the July 7, 2025 meeting of the Tupelo Planning Committee. Please take a moment to silence your cell phones. At this time, please rise for the invocation given by Lindsay Leak, and the allegiance will then follow by Patty Thompson.
Bow your heads, please. Heavenly Father, please be with us and guide our judgment, that those actions might be pleasing in your sight. Amen.
You face the flag. Attention. Salute. Pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. The Tupelo Planning Committee is a volunteer group appointed by the mayor and city council. We do not receive compensation and do it as a community service. The committee spends a lot of time and our own funds studying, researching the applications, and visiting the sites that are on our agenda each month. We ask that you remember that we do not take our positions lightly on any application. Our decisions are based on facts as they are presented and with regard to the regulations set forth in the city code. The Planning Committee may impose conditions on approvals of a request as it deems necessary to mitigate potential hazards or problems or bring the nonconformity into compliance to the extent necessary to protect the rights and interests of nearby property owners and the general public. At this time, I would like the staff and committee members to introduce themselves.
Tanner Newman, Director of Development Services.
Mark Williams.
Pam Hadley.
Leslie Mart,
Victor Fleitas.
Lindsay Leak.
Patty Thompson.
thank you. Our first order of business is the election of committee members. Bentley Nolan has been elected as the Ward 5 councilman and thus has resigned his position on the City Planning Committee. We will take this time to elect new committee officers. We have had a presentation to have Victor Flatus as our chair, Mark Williams as vice chair, and Aaron Washington as secretary. Is there any discussion?
I move we accept the roster.
I second.
Okay, so we had a motion by Patty Thompson and a second by Pam Hadley. All those in favor, please raise your right hand. And that is unanimous. The motion carries. At this time, I will turn the position over to Victor.
And Leslie, I do have a copy here of Bentley's resignation letter that we will make part of these minutes.
Thank you.
Thank you. All right, our first item is the review of the June 2, 2025 minutes. Has everyone had a chance to review the minutes of the last meeting? Are there any additions or corrections?
I make a motion that we approve.
Second.
Oh, wait a minute.
The date needs to be changed, June 2nd,
23.
5.
2025.
I do see that. It's got a missed date on it,
Yeah.
2023. With that, if there are no other suggested changes, with that change,
I make a motion that we accept the minutes with the change.
I'll second.
all in favor? The ayes have it. Next item on our agenda is the report on last council actions. Mr. Newman, do you have anything to report on the city council's actions from our last meeting?
None at this time.
Okay, thank you, sir. We are now ready to start our agenda. There are 3 items on our agenda tonight. As we work through these items, if you are here in order to comment on an application, please, when you are asked, move to the platform, speak into the microphone, and state your name and address before offering any comments. First item on our agenda is Flex VAR 25-03, request to allow a side setback of 4.5 feet rather than the required 10 feet in the low-density residential zoning district. The applicant obtained a permit to build a single-family house on the property. However, the builder set stakes that appeared to establish the property line, but which were in fact not accurate. The adjoining property owner advised the applicant that the house was too close to the property line. The house is now substantially complete but cannot be approved for occupancy without some resolution of the setback violation. Mr. Newman or Mr. Faulkner, have the surrounding property owners been notified, and were there any responses?
Yes, they have been notified, and we've not received any response. There may be some here tonight to speak, and we will give them that opportunity here momentarily.
Certainly. Will the applicant or representative of the applicant please come to the podium, state your name, address, and present your request to the committee?
Is the applicant here? Anyone to represent the applicant? Ms. Stanfield? Okay. Can you just give us an
Yes,
overview?
I
of
show the name of the applicant as Lucretia Stansfield.
My name is Lucretia Stanfield. My address is 912 Birch Street, Tupelo, Mississippi.
Thank you, ma'am. And would you like to present your application or your position to the committee?
Can you just kind of give us an overview of?
Okay, so when we went out to put the stakes out, the survey had surveyed the land and the contractor had staked it off, but the stakes, I really don't even know how it actually was. I don't know. We had it surveyed and we also had it inspected, and the stakes were within the guidelines that the city had for the setbacks. But then when we went back, it was too close to the property line, and so that's why we applied for a variance.
Thank you, ma'am. If you would, ma'am, just a minute. Does anyone on the committee have any questions for the applicant?
Yeah, I have a question. Anytime when you guys were building, were you made aware of that you were approaching the setback?
No, the only time we were made aware of it is like where the house had we had already got like 60% done with the house.
And who was that made you aware of it?
The property owner, that's
The adjacent property
adjacent,
owner?
yes.
And did you and the adjacent property owner talk about any resolution that could be had, sale of land to you to ease that?
Well, actually, the surveyor, he had a different surveyor than we had, and the surveyor showed him the survey and said, well, you know, the land that's in the back, they're not gonna be utilizing that. Can it be an even swap? And he didn't agree to that. So there was no resolution prior to coming to.
I have another question of you. Did the adjacent landowner, when the trees started being cleared, did he make note to you at all that, hey, the property line doesn't look right, that I believe this is my property?
He actually did, but he talked to he's not here. He talked to the man that cleared the land for us. He told him, he said, you know, this is really close to my property and I feel like this is on my property. And he said, well, the land is not on the property. The house is not on the property. It's just too close to the property line. And so they had a conversation between each other.
Okay. Excuse me just a minute, sir. I noticed that you came up, obviously with the permission of the applicant. Would you please state your name and give your address, sir?
I'm Jared Neal. I'm from Clarksdale, Mississippi, 2574 Simmons Road. And Lucretia and I are partners. We built one house on there, and there's a second house. I'm out of town. I'm not here. She was a project manager. It was my understanding that there was an old stake, and when they cleared the land, that's where the confusion started. There was an old stake, and they didn't get the new survey, but they used the older where the iron stake was, and that's where the confusion happened. And I spoke personally to the adjacent property owner and tried to do a resolution, and it was just a slither of land, and we couldn't get there because the price that he wanted for the land was astronomical. It just didn't make any sense for just a slither of land to pay the amount that was requested.
So are you saying that this mistake was really the surveyor's, I guess, fault, or can you kind of give us whose fault do you believe, who holds the fault for how we got?
I really don't think it was anyone's fault. When you have two stakes there, and when contractors are doing that, they went by the older stake, and I personally feel that it was just confusion. I wasn't here at the time, and they did show me once I went out where the older iron stake was, and that's what they went off instead of the new one, and that was where the confusion happened. It was an honest mistake. We had a good contractor who's done a great job, and he cleared the land, and he just didn't see the stake. It was a mistake.
Did you guys hire your own surveyor initially to survey the land and set the stakes?
Yes.
Okay.
So the survey here from Mr. Rex Smith, could you review this and just verify that this is what you believe is accurate as far as the property lines today and where the two houses are located?
Yes, sir.
I would agree that is where it is, yes.
So the original survey that you all had performed, did it match that survey? I know the houses would not have been shown there because they didn't exist at the time, but do two conflicting surveys exist, I guess would be the question.
Well, it's not two conflicting surveys. What happened after the issue, the initial issue with the property line, what Rex did, he moved it where the setback would be correct, and then he presented this, and I presented it to the city.
Okay, thank you.
I'm sorry.
Is your surveyor here today?
He's not. Sorry.
If I may ask a question or two, I'm a little bit confused on the sequence of events, so I want to make sure that I'm absolutely clear, if I may. And I direct the question to either one of you, whoever's in a better position to answer it. When the foundation was laid, when the initial work, that early stage work, to start this process of constructing this home, had an actual survey been done at or around that time?
The survey was done before any land was cleared, before any work was done. The survey.
How long before, how old was that survey that you relied on before you put that foundation down?
It was, what do you mean, how long?
How old
Maybe-
was it? Had
maybe-
you done one?
Maybe a couple
you
of
were
months, just a couple of months,
And so you have the name of that surveyor.
yes.
It's
And
the
what you're telling the committee is that that surveyor and the performance of their professional duties did their job incorrectly.
No, that's not what we're saying. He did the survey, and there was, the old survey, there was an iron stake on the other property, and when they put down the foundation, it's my understanding that as they were clearing it, that is the stake they used, instead of what the new survey should have done. I think his iron stake was lower than the existing.
If you had a new survey done, there would have been a stake put in when the new survey was done in the proper location, would there not have been?
I agree.
Why would anybody rely on something that was?
Mr. Chairman, we also have Patrick Reagan, our
Yes,
building
I'm
official.
sorry
here. I
if-
think he may have.
Would you like to
comment.
offer some clarification, sir, please?
Yes,
If you don't let
I'm
me-
sorry, folks, if you'd allow him to go, it may help answer my question. And y'all can stay standing or sit as you prefer and come on back to the podium. Yes, sir.
Patrick Reagan, building official for the city.
You have the floor, sir.
What happens, they had their land surveyed, the land was marked. It's construction, somewhere during the process, that stake got knocked out. There were other stakes out there, you know, just stakes. Their land, the man that did the land clearing, everybody saw stakes, assumed that was the property line, where in fact, the original stake had been knocked down, knocked over, kid pulled it up, whatever. The stake wasn't there. There was another stake. It's on a highway right away. Oftentimes, you know, who knows, had a stake marked out there. So I believe they did just mistakes and had some stakes out there. When our inspector went out there, our first inspection is always set to measure the setbacks. He saw the stakes out there also at that time when he did his first inspection. They were so far off the house that he didn't even pull the tape out to measure because he said, well, I'm well over 10 foot, which is our minimum. So our inspector even saw the stakes that apparently through, you know, some mistake, somebody assumed they were the property stakes when in fact they were not. And when the neighbor had his property surveyed, of course, they found this, he pulled a tape through there, and it was obvious at that point that the wrong stakes had been used during construction.
When the neighbor did their survey, how far along in the process of the construction of the home?
Like she said, probably 60%.
All right.
So I guess my question, for Patrick, let's just hypothetical here. If the committee were to grant this variance, it would clear up the zoning issue. Are there any other code issues as far as the fire code, building code, as far as setbacks go?
No,
Because
it is very close to being some issues, but from my understanding, we're 4.5 feet. So there will not be any building code issues. They're extremely lucky that it's hit the way it has, but there would not be any building.
so it's strictly a zoning matter.
It's strictly a zoning matter at this point.
I just have a quick question as far as, because you said that the adjacent landowner waited until the house was pretty much built before he actually pulled.
From my understanding, and I was not a party to any of these conversations, but I've talked to both sides, and the ones, the adjacent property owner thought they were over on his property or close to being on his property. He tried to say something. At that time, and this is, again, it's what he told me, is the following day he was deployed as a member of the National Guard. When he came back, the house was basically there and where we are today.
No, but he had said something before he left.
Yeah, and before foundation
Before
work
foundations
or
were
anything
poured,
was performed on the house. And, just due to being activated, he didn't have an opportunity to follow up.
Thank you, sir.
Mr. Chairman, I would like to have Mr. Faulkner kind of walk through the findings here as far as the requirements to approve a variance of this nature, and then kind of the findings to each of those points. You mind?
Absolutely, and then I think we need to let the applicant have an opportunity to.
Go through these things, same order that you can see them. With a variance, there are certain tests that are established by law, what you need to be able to find as a committee in order to approve that variance. One of them, the first of them, is that there's some special condition or circumstance that prevent the property owner from being able to use their property in compliance. For example, if there's a slope or topographical issue that makes some part of a lot unbuildable, that might justify variance being on moving the building on the lot somewhat. In this case, there's no special circumstance. The lot was large enough and level enough that the house could be located within the setbacks. The second finding is that if there is some kind of issue, was that something that was out of control of the property owner? And in this case, the issue of that made the variance necessary, the confusion over the line, that was something that was in the control of the property owner. Whatever a contractor, a surveyor does for you is deemed to be in the control of the property owner. So the third one is that the granting of variance was not give somebody a special privilege that other properties don't have for the same issue. In this case, that it would not be found because allowing a house to encroach on the setback is not normally allowed to other property owners. Strict enforcement of the code would deprive the applicant of reasonable use of the property. Now, in this case, there would have been room to build the house on the property if it had been made in compliance with the code. In fact, that the variance would not be materially detrimental to health or safety. There's not a real health or safety issue. I understand from what Mr. Reagan has said that the building code situation may, in some cases of houses being too close together, become a fire risk, but that's apparently not the case here. That the proposed use would be compatible with nearby properties. Again, that's not found because there's not other properties out there that are built this close to the setback line. And finally, that it would not result in the expansion of a non-conforming use. That one does not apply because it is a conforming use. In some, the application only meets 2 of the required 7 findings that are necessary for a variance. You don't have the case for. In particular, it's noted that there could have been a correction made at some time during this process, and it was not done. So there's a failure on the part of the applicant to make that correction is what makes it very difficult to approve this.
And Mr. Faulkner, what is the recommendation of staff?
Recommendation is to deny the variance application.
Thank you, sir. Sir, Ms. Stansfield, there may be some more questions for both of you. I don't know, and certainly I welcome you to have an opportunity to respond to some of the things that you've heard in here.
Although the expert, said that we only met 2 of the 7 conditions, please understand that we're 60% complete with a huge investment, and we have tried to work with the adjacent landowner to come to a resolution in order that we can continue to conform with the building setbacks. Our surveyor asked, we can do a land swap, and that did not work. So finally, when I got a chance to talk to him, just for the silver of land, he asked for $10,000, and that just makes our project it throws off the budget. And here we are with 60% complete, a huge investment, and I don't think that the variance is something that is that's detrimental. I think we could get along with the neighbors. We own we sold the house that's adjacent. There's a huge amount of land. We're just the setback, and it wasn't honest mistakes. Honest mistakes do happen. Yes, it was within our control. I will admit that. However, we're not contractors, and we do rely on experts.
Thank you, sir. I have 2 questions, if I may, and depending on who has the information. First question is, did the adjoining landowner approach either of you and have a conversation with you prior to the laying of the foundation regarding concerns about the setback? Did that conversation in fact take place?
The conversation that he had was with Mr. Neal, and Mr. Neal is the guy that cleared the land. When he told Mr. Neal that he thought the land, that the property was too close to his property. He and Mr. Neal had a conversation about clearing the land to build his house when he came back. And Mr. Neal called me and said, oh, it's no problem, we've settled what was going on, and I'm gonna do some work for him and clear the land that he needs cleared. And the next thing we heard was that there was an issue.
Did you ever speak to the adjoining landowner, ma'am?
When he initially called, I did speak with him, and he asked me, he said, I think you guys are building too close to my property. And I said, well, we had the property surveyed. He said, well, I'm gonna have it surveyed. And I said, well, our survey shows that we're at least 10 feet from the property line, and that's within the city code. But we were looking at different stakes,
All right.
or the contractor was looking at different stakes.
It almost sounds like this is a issue that the contractor would be responsible for not, doing their due diligence. And I don't know who the contractor is, but you're strictly looking at the facts. It appears that, that may be where the fault actually lies.
Sir, I have a question, and only ask this question because you mentioned the issue of cost, obviously, for dealing with the adjoining landowner on a sale of the necessary strip to eliminate this conflict. What are the costs of not getting that done,
Well,
or
obviously,
denial by this committee?
obviously, we won't get a certificate of occupancy, which makes the investment,
Zero.
Zero, yes.
Is that a better outcome than dealing
Well,
with your
obviously,
neighbor?
no, it isn't, and, we wanted to talk with the committee before making such a decision to know what our options were, and that's why we're here today.
Understood, sir. Thank you very much. Anybody else have any questions?
Victor, is anybody here to speak against?
Yes, I was gonna ask, is there anybody here who wishes to comment for or against this application? All right, hearing none. This closes the public portion of the application review. We are now open for committee discussion. We've already, I believe, received Mr. Faulkner's Development Services perspective on the application. Is there any further discussion or questions?
Oh, I was hoping to hear from the other property owner that,
Tanner, did you speak with the the adjacent property owner?
I have not recently. Again, everyone was notified within the 500 feet requirement, including that property owner. So that's as much as I can say about that topic.
I would have liked to have heard from the other property owner as well. I'd like to direct a question to city staff. What role, if any, does the initial approval based on the wrong stake have, or what consideration should the members of the committee give to that fact in making our assessment?
I think, again, I go back to the comment I made just a few moments ago that the contractor is responsible for verifying those property lines. When the city inspectors go out to measure the setbacks, they're relying on the lines that are provided by the contractor. And so when the city staff went out to do the initial setback measurement verification, that is measured based on the lines provided by the contractor. And so again, this is one of those matters. It's not personal. It's strictly business, and it appears that the fault would lie with the contractor, and it would be up to that contractor to correct the matter. And that's why we have security bonds to cover matters like this from a financial standpoint.
Understood.
Mr. Reagan, if you have any further comments in that respect?
That's pretty much sums it up. When we do our initial inspection, we rely, the contractor represents these as the property line. We're not surveyors. We have to go by what they represent as the property line.
And that meeting was with the contractor?
Yes.
When obviously the inspector has to be there with the contractor or representative of the owner. All right.
So that would be the Steve Schaefer
I believe Mr. Moore, Tony Moore. Is that correct?
All right,
Tony Moore is the contractor?
General contractor.
Jeez, understood.
Who is Steve Schaffner? Oh, there it is, Tony Moore, I'm sorry, my bad, that's me.
Do,
Was-
I'm sorry, Leslie, please. I spoke over you.
Well, I guess the question, would be really for the owners, whether or not Tony Moore was out there, and is that even pertinent at this point? Does that matter?
I mean, because, I mean, ultimately, if you're looking here, committee, if you review this single-family home construction application from Mr. Moore, the last page shows what the city approved as far as the setbacks for each home on Lot 1 and Lot 2. And then the survey provided by Mr. Smith shows where the home was actually built on Lot 1, and those two do not line up. So ultimately, what the city approved in this construction application, the location of the home on Lot 1 is not what the contractor built.
Please come to the podium, so you're welcome to make any remarks, but please come up.
Leslie, you said, you asked about the contractor, and the contractor relied on a subcontractor to put down the dirt pad, and that's where it all started. My understanding, the dirt pad, and that was Mr. Neal that Lucretia referred to, that put down the dirt pad. And so when the general contractor gets there, you know, he was not, he was more like a builder, that he was not involved in that aspect of it. He was not involved in that aspect. That was somebody that we hired to do that foundation. So it was a foundation.
So what you're saying is that Tony Moore is not the general contractor, he's your framing contractor?
No, he's a general contractor. What I was trying to clarify was that the subcontractor, Mr. Neal, put down the dirt pad
Okay,
for the foundation before the general contractor, even though that's under him, that he relied upon that.
okay. Who was managing all the different contractors? Was that
Yes, yes,
Lucretia?
mhm, that
So
was Lucretia.
Lucretia was acting as the general contractor?
No, she was project manager.
Are you guys doing this out of pocket, or did you get financing for this?
Out of pocket.
I'd like to direct the question to staff. As I see it, we have, not knowing what everybody's gonna decide to do, the option of approving, of denying. Do we have the option of holding the matter in abeyance for a period of time to see whether or not this problem can take care of itself before a final vote?
Yes, you certainly could table the matter and direct the applicant to work with the city staff to try to come to a resolution. And let me make this statement just for the record. We're not at all trying to be difficult here, and we appreciate your investment and are here, you know, to be supportive in every way that we can. But there are a lot of technicalities and legalities to take into consideration in matters like this, and so we just want to make sure that the bases are covered on everyone's part. And as city staff, we certainly would be willing to take on the role of mediating those conversations if that's the route that the committee chose to make.
Well, we appreciate your diligence and the questions that you've posed, and we do understand that there's a lot of legalities and certainly zoning ordinances, and we just appreciate the opportunity to be able to come here before you to make our case. It is an investment. We've made a conscientious investment in Tupelo, and we'd like to see those investments come to fruition.
Thank you.
I know that at least one member of the committee has expressed some desire to have heard from the adjoining property owner.
Yes.
And the absence of that, the absence of any verbal objection or present objection gives me a measure of hesitancy. I don't necessarily, speaking for myself, want to be just reflexive.
Well, and I don't want to deny it, because that, at this point, it would take a period of time before it could come back before the board.
And guys, I agree with all that, and it's unfortunate that the adjacent property owner elected not to participate, but he's not required.
Absolutely
to
not.
participate. So,
True.
you know, and we can certainly table the matter, but the only resolution, if we don't grant the variance, is they're gonna have to come to terms with the adjacent property owner, or the house will not be ready to occupy. And then it would have to be torn down. There's no other resolution to that.
And then I think you get into, again, and going back to the contractor, and, you know, in that scenario, they would have to be called on their bond, or they would be held responsible for the financial, you know, means here to correct the matter. And if that meant, you know, demolishing the house and rebuilding it in
Or
the correct
buying
look,
the adjacent land, and it's out of that person's pocket as
Correct.
opposed to yours.
I think those avenues, deserve to be explored before, I would be supportive of those avenues being explored.
I don't want to put additional obligations on the city, obviously.
So, my position in looking at this is, one, I don't wanna set a precedence, even though I understand we all make mistakes. I'm a general contractor, so I understand things happen. But I also don't want to set a precedence for something where somebody can just say, oh, I'm sorry, I've made a mistake. Let's not follow the code, give me a variance. That means that we're not really doing our due diligence with our job. My hope is that you guys would work with the adjacent property owner. Hate to say it, I've been smacked a time or two, but sometimes when we make mistakes, it costs us money. I sure don't wanna see your home and the property not being able to be utilized. But sometimes the lessons can be expensive. So I'm hoping that you guys would talk with them before, and really try and work through this. So if that is the ultimate goal, even if we table it, that means we're just putting off a decision one way or another versus making a decision. Even if we make the decision to deny it, would it then just go back to them to try and work with the adjacent property owner and come to some resolution?
Well, if, in the event the committee denied the request tonight, the applicant would have 3 days, to appeal that to the city council. Regardless, if the committee were to deny, I would welcome a meeting between the applicants and the city attorneys and I to sit down and really dig into those options, as far as if the contractor is the one that's held responsible, what does that look like, and what are the options there to correct that? So, whatever decision the committee makes.
I certainly agree with what Leslie has said. I would simply put this spin on it, is that sometimes problems can take care of themselves once you're actually at the point of decision. I see that happen in my work all the time, and individuals can take the information that they've garnered from this meeting. The city is willing to operate as an ombudsman. I think these applicants are fully aware of the financial ramifications of a denial versus an approval, and sometimes just allowing something a little bit more time to be thought through and talked to could lead to a resolution that works for everybody and kind of mops up the mess. I'm not saying that will happen here, and we're not talking about it.
And Victor, I agree, we can take that route, but at the end of the day, if they can't come to terms and they come back, you're gonna get a denial.
There will be a decision, and certainly, I think the applicants know where they stand better now than when they first came into the meeting.
We do, and Mr. Newman, and your willingness to work with us, we will try to do our best to try to work something out. And I think that option, we do realize that, and and we will do that.
I'm a firm believer in the better angels of our nature.
I agree with it.
I wouldn't be surprised if this matter got resolved.
Tanner, if we deny it tonight, is that putting any restrictions on the owner to still negotiate and do the things we're talking about?
It would not, by any means, it would not put any restrictions, I'll put it that way. If it were,
In my experience, it might make negotiating positions harder.
And if we don't deny it, then we've already set the established fact that there's only two reasons that were legitimate. would that come back to haunt us if we don't deny it?
No, I think all we're doing here today is holding the matter in abeyance to allow the parties an opportunity to negotiate. and
I'm
work a
thinking about the other
resolution out.
property owner. If he found out that we tabled it or we didn't do our due diligence and deny it, would there be legal ramifications for the committee or the city?
I see none. They don't have a right to have us do one action or another. They have a right to have the setback respected, as every citizen in the city has. But I don't think it affects us. Holding the matter in abeyance maintains the status quo, allows the parties an opportunity to operate on exactly the position they're in now.
But if we did not table it, we took a vote, and let's just say that it was denied, then both parties would know, you've got to do something.
Well, one party knows they would have to do something and be backed into a corner. It would create a certain measure of desperation that any prudent seller would be very aware of.
That's a
That
great
is,
point, Victor.
you
I
have,
see where
you
you're going.
have gold and I have food, and you can't eat that gold. That's my concern.
I see where you're going with that.
I'm sorry, I was trying to be,
Yeah, no,
I was trying to be a lot more subtle as we tend to.
Don't need to be subtle, just need to spit it out in plain
I
English.
my inclination is to preserve the status quo if it puts no extra burden on the city, and as Mr. Newman has indicated, they're willing to operate as ombudsmen to try to get the matter resolved.
I agree with that as well.
Yeah.
Is there any more discussion from the members of the committee? Do we have a motion?
I make a motion that we table it.
I second.
Okay. All in favor of tabling this matter until the next meeting
Well,
of the
Paul,
planning
one
committee?
moment before you
Oh,
vote.
I'm sorry.
Let's make sure for the minutes that the motion includes a request by the applicant.
Okay?
I'm sorry.
I make a motion that we table this and make the request to the property owners that they try and come to a resolution.
You certainly, let me, if you wouldn't mind, sir or ma'am, if you'd come to the podium. It's your application. Are you willing to have your application not voted on until our next meeting, to allow this process to go forward a little longer?
Yes.
Okay? I made the motion.
Right?
And I have second.
And it's seconded. All in favor? Right. Mr. Newman, would you please notify the applicants of next steps?
Absolutely. So let me give you my card, my cell number, if you will. Give me a call tomorrow and we'll schedule a meeting.
If it's in the service, he may be on 2-week tour. It's that time of year, so I think the 30 days will,
Thank you.
all right. All right, next item on the agenda, excuse me, I'm getting all man eyeballs out, is RZ 25-02. The property has two parcel numbers because it lies across a section line. Only a small portion of the 10.9 acres is suitable for development due to the location of a borrow pit on the back section. This part of North Gloucester Street, although near the Barnes Crossing Regional Commercial Area, has not been zoned commercial because of the Kings Creek Channel and adjacent floodplain. Mr. Newman, have the surrounding property owners been notified? Were there any responses?
They have been notified. There were no responses. I will make one note that the city is one of the adjacent property owners. A matter that came up during the work session last week is there is some confusion about the property lines with the fire department and the fire station. And we are working with our legal team to clarify whether or not some of the fire station property that's being utilized is actually on the applicant's property. And the applicant has made clear he's willing to work with us to get that corrected. So we do not see a reason for those conversations to interfere with the decision before the committee tonight.
We're talking about that little leg.
Yeah, if you look at the survey, it shows that the applicant owns the frontage in front of the fire department and then also the back parking lot of the fire department. We have identified a second deed that, where the city purchased that property on the front, I believe in 2007. The rear property being utilized by the fire department, that matter has not been cleared up, but again, we're certainly willing to continue working with the applicant to get that cleared up. They've shown their willingness and see no hindrance with the project that they have brought forward, and so we see no issue to hold up this request for rezoning.
All right. At this time, will the applicant or their representative please come to the podium, state your name, address, and present your request to the committee, please?
Hey, my name's Michael Pettit, go by Mac, 5159 Raven Avenue. This thing's messing me up a little bit. Okay, what I was looking to do with this property is I'd like to put a barbecue place out there. Kind of overview what I'm looking at right now. We're looking at roughly, I think the architect's 4,500 square feet or so. And what I'm looking at is a family-friendly place. I do not want, well, we're next to the fire station, and the boys keep a very clean lot out there, so we don't want any drunks, anything like that. We'll service a little bit of alcohol, but what I'm looking for is a family place out there. And what I'm most excited about, we have no neighbors except for the fire department. So we know that we can build our own little, you're at the mall, but you're not at the mall, if that makes sense. If you go back to that back of that property line where the pond kind of runs up it, you can almost create just doesn't belong at the mall area, I guess. That's the biggest thing. You're not looking at concrete. It's nothing like that. We're gonna, and with our other businesses we have, I believe our reputation, we're gonna keep a clean, like I said, family-friendly place.
The firemen are very excited about it, by the way.
Oh, I'm excited about them guys.
They don't have to go as far for food.
Exactly.
Really?
All right, sir, was there anything else you wanted to state?
That's it. Kind of like with Mr. Tanner was saying a second ago, with that property thing, that's I don't see how we don't work something out. There's not we all work together around here.
That's right.
So the main goal is we can build up a place out there with no hindrance. I know before we started this project, I know I met with Mr. Tanner and Mr. Dennis. I think Dennis Bonds, I think that's his name. I wanted to go over everything before I purchased property, before I did anything. I'm trying to make sure we go in the right steps. The approved contractors, architect, people that use companies that have company T-shirts and whatnot, right? So it's official type stuff, right? So that's what we're really looking to build. Right now, I know. Looking for, I guess, for that next step. We've been planning this, I guess, out for a couple of years, been saving Lord knows how long. And that's just, yeah, just really excited about it.
Thank you, sir. Do the members of the committee have any questions for the applicant?
Yeah.
All right, sir, thank you very much.
good
You may
deal.
be seated.
Thank y'all for y'all's time. Appreciate it.
All right, we will now open the public portion of the hearing for this application. Please try to hold your comments to a maximum of 5 minutes. Is there anyone here to speak for or against the application? Please state your name and address when you come to the podium.
My name is Mar Asher Galley, 1408 Orleans Place, Tupelo, Mississippi. I'm a neighbor to, I'm approving it. I like to see it happen in Tupelo, but at the same time, I would like to have access to my property. I'm a neighbor.
Is this a residential home that you're talking about?
No, it's not a residential home, nothing. It's a land.
Where are you at, sir, on the,
Right here, sir, this triangle. If you give me the access when I need it to use the property, I'm fine with it.
would you show the committee the referring to?
Yes, sir, thank you.
Yes, sir. This right there, this triangle right
I see, you've got a,
there. Yeah. The A/O right there.
understood.
I'll get the access, I'm fine with that. I'll walk
So you're saying it's this piece of property
Yes, ma'am.
that is right behind
Yes,
here?
correct.
Did you see that, Mark?
they give me the access to it.
Yeah. So
How did he have access
He's
before?
landlocked, he doesn't have access to it today.
Well, he has an easement by necessity, doesn't he? If you're landlocked.
Choked up, if I could,
So there,
access to it in the future, I sure appreciate it.
Okay, if you.
All right, sir, thank you. Please return to the podium.
is there
I
currently?
just want in the future not to be denied to access the property. I mean, I'm not, objecting to
Sure.
it.
So, but
I'm
currently
the opposite to that.
there is no easement across the property?
No easement at all from all
Have
directions. This is
you-
the only way you could get into it.
Well, I would like, before
Yes.
we have any further conversation, I would like for Mr. Faulkner to offer the staff analysis and then direct any questions about historically, how has the city handled?
I mean, in the
matters like
future, if in case I had a use to it, or I need to sell it, or, would I have access? That's,
When you bought it, you would have known what access you had from it. The closing attorney or your attorney would have explained what your rights.
No, sir, I didn't have no attorney. I bought it long time ago, about 20 years ago at the tax sale.
And have you had anybody run the title?
Nobody on the title since then.
You've not requested it.
I never requested.
You've not looked to see what the deed.
My name is on it, but the
No,
deed,
I understand, but when you buy it with all of its history. Have you
Yeah.
had anybody actually go? and
nobody
look at
come
history?
through all of those years to claim or
Well,
nothing.
you have not requested.
I never
your right.
request, yes, sir.
You could hire somebody and
I
have
could
that
hire,
done.
but that's my last concern. It's just a property, Give me my initial investment and they could have it.
Well, I understand, but our decision can't be based on your property.
No, it can't. But I'm requesting that if in the future I would,
We
get
we
the
could-
access to property.
We couldn't give you that. If we said we were gonna give it to you, we couldn't, because
Okay.
that's determined by the laws of the state regarding real property. We don't have the authority to grant an easement where
I
where none may
understand that.
exist. And
But if in the
usually a
future he
landlocked-
would like to purchase it or buy it, or anybody come, I'm open to sell it.
I understand, sir. I got you now. Thank
You
you.
just have that sliver, the
That's-
triangle?
That triangle, yes.
Okay.
Been 20 years ago, but.
Okay. Thank you.
Understood. And you acquired it through a tax sale?
Yes, sir.
Understood. Thank you, sir. All right, at this time, I have it,
The applicant may have some comment.
yes, I'm sorry. Did we want to have a
No, Mr.
staff
Pettit.
analysis
Yeah, no,
or?
Mr. Pettit had a
Yeah,
comment.
Mr. Pettit, if you would, please come up so that you could,
You're probably gonna answer my question. Seeing the man that knows answers. Okay, I'm kinda, didn't expect that part. So y'all don't, that's not a real thing right now, I guess. I don't know any way to kind of say it, but you, like with easements and stuff like that, that's not a,
It's not something the committee can.
that's nothing
that is
right here.
outside, that's outside of our pay grade.
Thank you very much.
I think.
Hey, let's,
If we
we'll
could
let
please
Mr. Faulkner
hear- if we
confirm
could-
or correct
If
us.
we could please hear the staff committee recommendation from Mr. Faulkner, who will set us all straight. Thank you, Mr. Faulkner.
Well, the tests for zoning are on a different level. They really don't get down to the questions of the details of the description of property and that kind of thing. What they do ask about is, there's a reason that this property has been zoned agriculture open space, and is there a good justification for changing it based on those conditions? Well, agriculture open space is intended really not to be developed unless it's really needed, because it's typically floodplains, and whenever you develop in the floodplain, you've got to spend extra money to be able to be safe and to get your insurance. When the zoning maps were made, agriculture open space was zoned along these floodplains, even though the area is in proximity to the commercial areas north and south. But this also is a holding zone. It understood that at some point, some of the agricultural zone land will become developable and demanded by the market. And the test is there a change in the neighborhood, in the vicinity, that justifies a change in ordinance from undevelopable open space land to developable commercial land. In this case, the big change, of course, is the development of the target property on the other side of the highway. That will do two things. One of them, it will bring more commercial activity closer to this area. And it also takes up a great deal of the land that was available to the Barnes Crossing commercial district. Because of that impact on the supply of developable commercial land in the city, there's now a market need for more zoned commercial land. And for that reason, the staff is recommending approval of the rezoning.
Thank you. Mr. Faulkner?
So, Pat, I do have a question.
Sorry.
Am I allowed to ask him that? Is this
Yes,
now
you
the time to
could,
do that?
yes, you could, well, anytime someone speaks, the committee members can ask a question of that individual.
Thank you.
Of course.
So, in looking at the zoning map that shows the floodway and then the green area, which is the AO, since part of this property is in the floodway, does construction there or rezoning affect the insurance for that property? I'm questioning that. So is this now gonna be in a flood zone? Since
The-
we're right next to the floodway?
The city zoning districts and the flood zone designation are two separate animals.
Okay,
You know, if we zoned the whole flood zone commercial, it would still be a flood zone. But that flood zone's still gonna impose its requirements for being allowed to get a permit there. Understand they've got to elevate the site, they've got to manage the water coming off the site in certain ways in that flood zone that they don't in other places, but our zoning decision doesn't affect it.
Pat, one thing that came up this week, just amongst staff, is the fire station. Should we go ahead and rezone that property as well, so that it is not spot zoned AO? They're kind of landlocked on its own. Do you have any thoughts on that before we send the recommendation to the council?
Well, it would really probably not have any practical impact. It would still be a permitted use, the public safety station in the AO zone. It would clean up the map a little bit, but, you know, and simplify the way it looks, but in terms of function, not necessary.
Do you
Certainly
have
the city could agree to include that area in the rezoning action if it
Do you
wants.
have a recommendation on that, a yes or no, as far as should we go ahead and make that recommendation tonight when the committee votes to send their formal recommendation to the council?
I would say so, yeah.
and also looking at the same map, it looks like there's this weird strip that kind of connects the property that they're purchasing, and it goes along the one that's landlocked and then continuing around the back. What is that? Do you know?
I don't have the map in front of me either.
Pat? So here's the property. What is this?
I'm wondering if it's an easement or if it's a utility line.
Okay.
It may have been something that was
Do you know?
an artifact of the canalization of the stream there.
All right, and is there distance requirements from I-22 that limits how we could rezone the rest of that green area, rest of this?
Or is there a need for it, I think would be the question.
Well, as we're talking about additional properties, you know, what's happening back here? You see?
I think one reason to leave it as AO is because in the event that there's a developer who wants to develop it, it forces them to come to us on the front end because it's not zoned commercial, so
Gotcha.
that we can
That is a
notify
land use.
them,
Gotcha.
one, it's landlocked, and that it's in a flood zone that would have to require additional work and funding to develop it.
It is a landowner by landowner decision whether they want to seek the zoning that's being sought by Mr. Pettit
Yeah, correct.
and us
It
not just.
serves as a layer of protection, honestly, for the property owner, so that they do have to come have the conversation that Mac did on the front end, hey, what would it take for us to develop this site? And, you know, one would be, it needs to be rezoned, you have to have the floodway, you know, work from an engineering standpoint. So, you know, again, I would recommend going ahead and including the city property there, and that would be the extent of my recommendation.
So you're saying the one that's listed is 084S 18-010-00 and 084U 19,
So those are the two parcels, Mr. Pettit's requesting.
and then the
and
fire
then-
department.
And then we're saying, and add the fire department, parcel to that recommendation.
All right.
Mr. Reagan, do you have that pulled up? Could you give us that parcel number for the fire station?
084S 1801
084S 18-01-001.
Yes.
Thank you.
Too many zeros.
Say that one more time, just for clarification. 084S 18.
010 dash 0.
Okay.
If we moved ahead with doing this, do we need to put any language in the motion about the corrections of the city land, that it's not as shown on this plat?
I would just make a note for the record in the minutes that the property owner, the applicant, has agreed to work with the city and that we are working together to correct the map and the property.
To determine.
Yes. And if you include that parcel that the fire station is on in the rezoning, then there, you know, I think that does help clean up the map. And ultimately, if we need to have those lines corrected, which it appears we will need to do that, it's all zoned the same, and there's not part of a parcel that's zoned agriculture, a part of it that's not, that's owned by the city.
Are there any other questions? Well, before, Mr. Pettit, sir, would you like to make any remarks in light of Mr. Faulkner's presentation? Any other questions from members of the committee? All right, this closes the public portion of this application review. We are now open for committee discussion.
Will, since they're so close to a fire department, are they allowed to serve alcohol that close?
Yeah, I'm not aware of any restrictions on that topic.
Okay.
Victor?
100 feet between buildings.
100 feet. And they would still have enough room before getting into the floodway.
Yeah, under their site plan that they provided, from their engineer, we've cleared all that up on the front end. And I will commend Mr. Pettit for doing that. You know, the way this process has worked out is exactly how it should. He came to the city on the front end, said, hey, this is my vision, this is what I would like to do, you tell me how we get there. And that's what he's done every step of the way, so, thank you.
So has there been any thought, discussion about access onto Gloucester? That's a
Yes.
pretty
So-
weird little,
MDOT will have to issue the permit, and that's something we'll get with you and your engineers on. They have recently, in relation to another project, clarified that they do not want another red light in that vicinity between, I guess, I-22 and the Blue Canoe area. And that's something that MDOT is working through on, you know, future recommendations, but currently they do not want any additional red lights along that stretch.
is there any discussion about an access road?
There's not been any active discussion that I've been privy to.
Sure would be nice to see a little bit more of that kind of thing to limit all the stoplights.
Honestly, I think that, you know, you're fishing to see, once Target is completely built out and opened, and the new access road is built, connecting Gloucester to Barnes Crossing Extended, I think once all of that's in place and we see the traffic at that point and what those patterns are looking like, I suspect you'll see additional conversations between MDOT and the city on what that looks like.
That's the only questions I have.
Are there any other questions?
Can I
All
make
right.
a motion?
Is the committee ready to make a motion on this application?
I make a motion that we rezone the parcels 084U 19 008 0 084S 18 010 00 and 084S 18 010 01 to be
MUCC.
MUCC.
Second.
We have a motion and a second. All in favor?
We do need to make the note that the city will be working on fixing the,
Identifying the actual property lines
there you go.
and clarifying,
The applicant
for
and
the
the
record.
city will take
Okay.
all measures to determine the property lines with the fire station and the adjoining property.
Yes.
thank you.
All right.
Thank you for
Thank
good
y'all.
language.
Thank y'all.
Boy, Pat. Wow. For the
All
tough
right,
one.
the next item on our agenda is,
And I did not print out that new list.
oh, that's all right. Next item in our agenda is TA 25-01, proposed amendments to chapters 2, 4, 5, and 11 of the Tupelo Development Code to provide definitions and zoning classifications for brew pubs, microbreweries, liquor stores, and convenience stores with fuel service. I believe this matter is being presented by the city. And if you're ready, Mr. Faulkner?
Did you print out the big version that Pat sent?
Here's a
Did anybody print out the corrected version? Pat, you sent out a corrected version of the Park Hill business or residential?
Residential, we got that in the email.
Well, what you got first was incorrect. That was the guidelines for the business district. And so the correction was for the residential overlay district. And that was the primary part of what is being discussed tonight. You have, this was in the packet, and this is the business overlay district.
Correct.
And this is the actual residential overlay district. When you look at the Park Hill neighborhood, you go west from the business district into the area along Church Street and Barn Street, Walker Street, those areas going west. This is an area that the city and Neighborhood Development Corporation have undertaken to redevelop. And the corporation's been actively involved in just meeting with property owners and buying property, and have about, between what the corporation has and what the city has, about 30 lots now. And at some point, probably in the next few months, we'll be beginning to actually master plan how to start rebuilding new houses in this area. In order to have some control over the houses that get built, obviously those that are built on land that the city or development corporation owns, they'll have covenants that have these standards in them. But for the rest of the property, you know, that are still gonna be remaining in private hands, there'll be an overlay district and a review process that will be handled by 3 members of the neighborhood, and 2 members from the Development Corporation. City has used this process on West Jackson redevelopment, and it's worked pretty well. I think we've learned some things in that process that we can simplify this one. In particular, we wanted to make sure that these guidelines do not drive up the price of housing too much. The city council was very firm that they wanted this project to deliver some affordable housing. And it's going to be tough just because of the cost of construction. So we didn't want to throw a lot of design requirements on top of that and keep driving the cost up and not be able to meet the need. So what we've got and what we put together was with the consultation of neighborhood representatives, Development Corporation representatives, a contractor who's built these type of houses. And really, it's a stripped down set of standards. The only really architectural features that we're going to be real specific about was roof pitch. Roof pitch is not supposed to be less than 6 rise to 12 run, and not more than 8 to 12. So you have a pretty normal type peaked roof. Don't want any flat roof. Don't want any modern looking steep roofs. In between that, you're probably going to be good. There will be a requirement that they put a porch on the front of the house. It's not a big porch, but it's typical of what's in that neighborhood now. And we feel like a porch adds visual value and compatibility. Finally, there's the elevation of the pad. It needs to be at least 12 inches above the level of the street, partly for drainage and partly just because, you know, the house needs to have that little look to be consistent. It's also a maximum of 30 inches, so you don't have things jacked up on a big mound above the street. That also creates some drainage issues. So.
Pat, did we add language about the fencing? If you have a chain link fence, that it would need to have a vinyl coating, black or?
He did. It's
Yeah.
in that new version.
Okay.
Yes, that is in there.
And what was decided about a carport or garage requirement?
The carports are permitted if they're attached to the side or the rear. With a garage, it's also permitted. There is a limitation that if you have a front-facing garage, that garage width not be more than 40% of the total facade length of the house. That's partly to encourage, if you're going to do a big garage, put it on the side, and also because you don't want the garage to overpower the house.
Yeah. I know we get a lot of complaints, code enforcement does already, about Park Hill as far as the street parking, of the abundance of street parking because there are no carports or garages. And certainly, as Mr. Faulkner indicated, we would like to see affordable housing here. I do think that the question of do we put at least a minimal requirement of a rear carport, not a garage, but carport, is something for the committee to consider and discuss before we make a formal recommendation to the council. And that's the only additional, I guess, request the administration would have, is just to at least have that conversation.
Pat, if the majority of lot sizes in there, would that afford that to happen?
Yes, there are some very small lots, but what we're trying to do with the replatting, when we have that property that we can do so, would be to make 50-foot wide lots, which should be sufficient.
If you look at some of those properties on Chapman Drive, they're roughly 50-foot lots, and most of them have a rear garage. But my thought to keep the cost down in this neighborhood would be they could have a rear carport to
Rear
at least
or side.
rear or side, certainly, but just to at least, I guess, take a proactive step to minimize that street congestion, because those streets are not wide. They're not full, typical neighborhood street widths.
Well, I know in Fair Park, the notion of street parking is actually thought of as a speed reduction measure. Would it operate the same in the overlay district?
We think so. Some of those streets now are very narrow and will probably be widened as through this project over the course of time, just to meet standards. But, they won't probably be much bigger than the ones in Fair Park. So, yeah, the traffic calming would be a result of that.
But I'm kinda like Tanner, I like the idea of them, us having the requirement in that code that they have either a garage or a side or rear carport.
Even if the requirement was just a single carport,
Sure.
at least it gives it some, at least it gives us some, I guess, leverage there to, because again, the houses that are built on the property that NDC or the city owns, we will have the stipulations in these deeds, for those properties, but we're not going to acquire, let's just be realistic, we're not going to acquire every property in this map. And so, if you have outside developers coming in to build, especially additional rental properties, we just want to make sure that those new houses that are built outside of the deed stipulations, NDC and the city control, that they do have some minimal requirements to protect everyone else's investment.
All right, what about, metal roofs? Were we going to require a minimum type, if a metal roof is used, it has to meet a certain requirement?
That's one of the areas that we felt like would be a trade-off. Yeah, you would get a better product if you specified a standing seam metal roof, but you'd also be substantially increasing the cost. We, in discussion in the committee that drafted these, did not feel like it was justified.
Did the committee have an opinion on the issue of the single carport, rear or side?
No. We anticipate that people building for the market would do that. Everything that was built in West Jackson had a carport or a garage, just because they felt like they needed to be able to sell it. So I'm not too worried about that happening, but again, we don't know for sure.
And I'd like to codify that to make sure that they do. Because the first time somebody decides, oh, no, we're not gonna do that, they'll put a sidewalk on, no driveway, cause there's no carport. And then all of a sudden you have people parking in the dirt.
Yeah, I mean, again, I think the overlay guidelines, again, will be in place to protect those properties that the city or NDC don't have jurisdiction over. And I think it's important to remember that concept as we discuss this topic.
Existing properties and owners will be grandfathered in.
Correct.
Yeah, these guidelines would only take effect for new construction.
Mr. Faulkner, I have two questions, very quick. Number one, neighborhood committee, have they indicated their support for this district?
Yes,
All right,
Yes.
and has the councilwoman for this respective district expressed approval for this?
right. She's been involved in those discussions.
Thank you.
Normally attends the meetings of the Development Corporation.
As I understand it, our job today is to take what you've given us, maybe offer some recommendations, but we're not taking any final action today. Or are we on the overlay
Yes,
Yeah.
we would like you to make that action today.
with any recommendations?
Right.
Understood? All right.
So, Mr. Faulkner, I had a couple more questions, I'm sorry. And pardon me for not printing this, cause my phone's not cooperating. Sheesh. I had made some comments about and this is really just housekeeping, it's not about the code for that specific area as much as it is some of the general requirements, like the timing, 1 year for the committee members, and that needs to be submitted in September. We had September, October, we had started that in some of the other overlays, so that there was not this continual flow every month of something else to come, for approval. So that would fall under the review procedures.
Yeah, Leslie, you sent that out, and I think you sent it out when you did it, you used it the business overlay instead of the residential overlay.
Thank you for catching that.
Yeah, so I think your reference like, 5.64 is really 512.4 review procedures.
Okay? The 5.6 came from
The business overlay.
the others, yeah. So the email that I sent had several things that we had implemented, whether it's in Joyner overlay or in West Jackson overlay. And, you know, it always happens that something gets added to the code because there was an issue, and then we had to codify it. Is that codify or codify? It doesn't matter.
Tomato, tomato.
There you go. So, I know, like termination of members, for instance. Some of those things I feel like it should almost be a general part of the code for all the overlays, so that it applies to all of them. And then this way, we don't have to keep writing it in for each overlay. Some of it's just kind of common sense that we should do that, or we could do that. Does that make sense, what I'm talking about?
Yes, ma'am. I understand. You want to have a universal provision for all overlay districts instead of including it in each one.
I think it may be helpful.
I think we would have to have an additional, I don't disagree at all. We would have to have an additional, public hearing for that specific code section. And I'm not at all opposed to that. If that's a request, or the will of the committee, then we can certainly get that on the agenda for next month.
Okay, can we
So-
at least put this part in on here, or is it, are your thoughts, what's the committee's thoughts on having such detailed language?
Yeah, I liked your draft in the review procedures to be included in the residential overlay. So I don't have a problem with that, Tanner. I'm just saying if we do that, is that gonna delay the city being able to take action at their next meeting?
Now, I think we would treat it as two separate items. If we wanted to go ahead and include it in this language tonight, I don't see a reason not to do that.
Okay.
But if we would also additionally like to have that, incorporated into the head section of the overlay chapter in the development code for all districts, then I think we could do that as well. It would just have to be a separate.
In the future and different.
And would that then have to be recognized by the Park Hill Residential Neighborhood Group, that this is now being put in?
It would have to be, yes, but to keep it clean tonight, I think go ahead and include it in the Park Hill residential language in this code section. But then additionally come back and include it for all districts in the first section of the overlay chapter, for all.
Yeah.
When
So
we were
we had problems
discussing
where,
this with the,
one, somebody died, and then we
uh,
had, I'm sorry.
with the design review committee that was drafting them to start with, I explained that there might be some language changes at this level or at the city council level, that you have authority, the council has authority. They understand that.
Great.
We don't have to go back to them to get approval to come back
Yeah.
here.
And just for everybody's information, I'm not gonna name anything, but, on both committees, we've had a death. So we had to figure out how we handled that. And then on another, we had one member that wasn't acting appropriately. So that's how that language kinda came around. And so it's better just to be safe than it is not to be.
And that language is part of both of those overlay districts, Leslie?
It is definitely part of West Jackson.
Gotcha. So its language has been
It's
used
It's
in,
definitely part of Joyner. Yeah.
I'm not gonna speak for the rest, to be completely
Yeah.
straightforward. The Jackson West overlay and Joyner overlay are the two most active that we deal with routinely, just because of the amount of construction taking place in each of them.
Sure.
So I can speak confidently to the nature of their language, but the other ones, not so much.
All right.
And we have a very active design review committee. All right, and then this one also already covers then the dates, so this way everybody's on the same cycle.
Could we just
The
get a little
language would have to be changed to state the Park Hill overlay district, as I think yours had
residential over?
Jackson Street.
So how do we get this into the notes or the meeting minutes or
Wouldn't-
whatever?
We would work with the legal department to draft the ordinance that changes the
Yeah.
code, and we'll work it in at that
Just
point.
make it clear in the motion
motion.
of the intent of what the intent is. And then also, I think just to clarify the committee's position on the carport requirement before we take a vote.
I do remember there was one other really small item on sub 4 regarding, shall meet to consider permit applications no later than, and I think there was that an amendment or was it a correction of 10 days?
It was a change, yes.
Okay,
From-
so we don't need to include that in the motion.
Right, from 30 days to 10 days.
All right. I know that would have to be included as well
Yeah.
from the work session.
And I thought you fixed that by saying there was like 30 days from the date of submission to development services. I thought I read that somewhere.
The design review committee shall meet to consider permit applications no later than 10 days after the complete application
Okay.
is received by the Development Services Department.
Perfect.
That's sub 4,
There it is.
5.12.4.
Okay.
It was 30 and the request was made at the work session that it be 10.
Yeah, so for the other two committees, Joyner and West Jackson, it actually is 7. They have a week. Once we receive it, we have 1 week to
Mhm.
review and get it returned.
You guys on the Joyner and West Jackson committees are used to this process and they stay on top
Yeah,
of it.
Park Hill,
Gotcha.
Park Hill
Okay,
walks at a
okay.
little bit slower rate.
I
Yeah,
got
We're
you.
getting there.
We're getting there.
We're establishing the.
Okay.
Yes.
Pace of life's a little bit slower in Park Hill.
And we may come back, at some point and change that, but I think on the front end, it's probably good to give these guys some flexibility, to work with them
All right.
and then we'll change it if needed.
All right, and the language is the same, but I will say that for Joyner and West Jackson, meeting can be something as simple as emails.
As
It
it
is
should be.
not a physical, like they have to physically meet. They don't even have to physically talk.
Everything that the committees review are things that can be reviewed via email, and we encourage that.
Okay, so we don't need to, the language is okay the way that is, right?
I think so. That,
I think it is.
Okay. All right. So you guys are not gonna go for the metal roof? I mean, you're gonna allow just shed roofs? I have
I mean,
real
let's-
heartburn over that, I'll
I-
just tell you.
Look, personally, I'm personally am not in favor of allowing them. I understand the thought behind, hey, we're trying to encourage affordable housing here, but I think we also have to, protect the surrounding property owners. And again, I go back to when the city or NDC hires a contractor to build on these lots, I would make the request that there is no metal roof. But we can't control the, private property owners, next door without the overlays. The overlay is the only guideline or justification we have to hold them to a certain level of design standard. So
Guys, I just really gotta tell you from my position, not only in contracting, and Patrick even noted that a metal roof only has a 5-year warranty. And so I think that we have an obligation to protect the new homeowners, to help the new homeowners. Sure, a shingle roof is not gonna last them forever, but it's gonna last them 20 years versus 5 because they weren't doing the maintenance. And if you do not do the maintenance on those roofs, they will leak. It will leak. That is just what happens. And I just feel like fine, you wanna allow metal roofs, you can say metal roofs are allowed if they are equal to a standing seam. That way, we're not saying you can't have it, they're not gonna do it, but we're not saying you can't have it. But I feel like we're
And
just,
two, you know, even look at some of the houses on, I believe, West Jackson, where you have a standing metal seam, kind of like, you know, like carport or porch, you know.
we allow
kind of-
shed, we allow the
Decorative.
decorative metal roof, decorative over the porches, that kind of thing. But as the general rule of the roof, it has to be shingle or, we don't even allow metal.
I mean, I think about the house on Chapman that the city purchased that was kind of the last man standing, that was holding up the NDC project along West Jackson or Chapman Street, that was a bright red metal roof on a old stone house. Do you think we would have these contractors building these nice homes on either side of it if that house was not gone? Or if that old home that was dilapidated with a bright red metal roof was still there?
Yeah.
No, you would not. We can't put in here, hey, you can't have a red metal roof, or you can't have an orange or a bright blue. Those are things we've gotta take into consideration at this level and at this point.
And we know that they could put red shingles, but it's not bright. They could put green shingles. But it's, for me, it is about maintenance and about providing quality housing for these people. For a lot of these people, it's gonna be the biggest investment they ever do. And you want to be certain that their investment is gonna last. And, you know, Lindsay, you're in real estate. How often do you see houses that have the cheap metal roofs that they end up having mold issues?
Yeah, it happens.
It happens a lot more than folks, well, Patrick's in the new construction and renovation, but it happens a lot more than folks know.
Yeah, and so, Pat, I appreciate the comment. So was this, I think you said this was discussed, and the group that put this together did not want that in there.
Because of a cost prohibition. It can make the entire project fall apart, because the purpose of it is small homes, affordable. People who buy a home know they're making a big investment, and it's up to them to take care of their homes.
I would say if the committee voted to allow metal roofs, that at the very least you put a stipulation that the color, you know, must be a neutral color that individually must be approved by the overlay committee. So there is some guideline or something in place so that we can avoid these bright, outrageous colors that throw off the entire characteristic of the neighborhood. So if it's a gray, a black, a brown, you know, give the committee some leverage to hold these builders accountable.
So as I'm looking at, based on what you mentioned, sir, 5.12.3.1 standards, sub E, roofs, you propose that we include an amendment to permit the overlay committee final approval on roof color.
Yes. Pat, do you have any strong feelings?
No. Final approval of roof color at discretion of overlay committee?
Yes. The overlay design committee.
I thought you were just gonna say a neutral color.
I think you give them the,
You-
yes, certainly a neutral color, but if they're
Don't
going
give
to-
those people, don't give, and I don't mean those people, I mean, don't give people the right to pick colors. Because then you start getting into opinions and,
Well, I think they have to decide though what is neutral color, you know, so we can sit here right now and say it's black, it's gray, it's brown. I don't know the exact language. I think probably the best thing is to include in the motion what our intent is, and then let Pat and I get with legal
you know,
and decide the exact language to,
neutral tone
yes.
color.
Sure.
Was everyone,
Yeah.
to
I'm
me, be
fine with
comfortable with that?
Yeah, but don't,
I'm with you, I hear you.
yeah,
I hear
you start saying, you know, because somebody could say, hey, I like pink, because that pink is neutral. Don't ask people to make color choices.
Would the members of the committee, before we vote on the overlay district, like to propose their particular amendments to it? We vote on those before the whole thing? How do y'all wanna proceed on it? Cause I know we've got at least 2 items that we have to include by motion. The date, the amount of time change after receipt by the committee, as well as the single carport request.
And the roof.
And that's a third, so I know we've got at least 2, there's 3, and I don't know that members
Leslie,
may
do you
have
wanna make
others.
the motion with all of those combined? I think if we can make one motion with.
So truthfully, I don't, because I do not emphatically agree with allowing a metal roof. And I wanna make sure that I have some venue to say, I agree with, X, Y, and Z, but I do not agree with allowing a metal roof.
Understood.
Respectfully, thank you.
So we are doing the single carport. We have a requirement for a minimum, right? Of a single carport on side or rear, or an enclosed garage.
Yes.
And then if the enclosed garage, it cannot exceed 40% of the front-facing facade.
And the foundation.
Yeah, the foundation. Did that get changed, Pat? I'm sorry.
The foundation is in the draft.
Yeah, it's in the draft, that hasn't changed, that I've seen, that's in there. 12 inches from the horizontal surface of the street or sidewalk.
We had
All right.
something about 30.
It was. And so here's a maximum,
No.
and it is in Pat's draft under
Maximum.
F.
Okay,
It's already in there, so
All
we
right, so
don't
we don't
have
have
to
to
add
include
that, no.
All right.
What his version says is, shall be elevated at least 12 inches from the horizontal surface of the street or sidewalk, and shall not be elevated more than 30 inches above the same.
Hey, guys, we're writing a lot of this on the fly.
Yeah.
And I think it may be wise that we table official approval of this and bring this back into a work session to get it down into what we truly wanna represent to the city council.
I don't disagree. Pat, do you see a reason? What's,
Another month won't hurt us, I don't think.
Oh, great.
you don't.
Okay,
Alright.
oh, that's
No,
great.
I'm fine with being measured and taking more time to get the language right. If, my feeling was just give you guys the broad language to get it hammered out yourselves, but I'm fine
I
with,
think do that, and then we'll bring back the final draft that everyone's comfortable with after legal works through the kinks. But
Okay.
if we could at least make it clear what the amendments are that the planning committee is requesting on the record, make that a motion that you're requesting, a final version or a final draft to be brought back at the next meeting, I think that would be appropriate with
Okay.
any XYZ amendments.
And so our XYZ would be review procedures, the single carport and garage, and then roof. Are those the 3 things?
And anything on the foundation requirements.
He's already got that he already wrote that in.
And the
Yeah, it's
10-day
in-
review.
It's in some of these
That's already
documents.
in the other draft,
Not in all of them,
not in all of them?
yeah. And I
Okay,
don't know how,
I thought that was still something we had to act on.
but I've got the notes on all 4.
And Leslie, did this pick up also your draft email from earlier today about designated electing appointed entities, termination of members?
Yes.
that was the review procedure to implement the review procedures for the email, and I copied Pat
Okay.
on that, right?
So if we're going back
Yes.
to bring it back next month, that can be incorporated.
And Leslie, you
Okay.
wanted a motion on no metal roofs, except for the particular.
How do we do that? If I know I'm not going, I don't wanna vote for that particular portion, then when we do the yay and the nays, I can do a.
Let me
I
get
can
with
do
that, let's get with legal between now and then and
Yeah.
confirm
Yeah, I
that,
mean,
'cause I don't wanna mislead
all we're
you.
doing tonight is just making a
Right,
comment to the city council. We're going back, and here's some of the areas that we're tweaking for final review. So
Okay.
that's not an official vote or
Right.
anything by
Right.
anybody on this committee.
It will
Sounds good.
come up at the work session.
okay. So I can make a motion. You guys want me to
Yeah.
do that?
But hold on,
All
before we
right.
do that, we need, for the record, to have a public hearing for this item and the other text amendments, because tonight was the
Absolutely.
advertised public hearing. Just wanna make that clear for the record.
Let me
Alright.
ask you this then, if we have to re-advertise,
We don't. There's one public hearing required at the planning committee level, one public hearing required at the council level. Tonight suffices as the public hearing for planning committee, and the result of that public hearing, is committee sending it back to the department for the final tweaks.
That's
But
right.
I just wanna make sure for the record that we do.
I'm gonna
merge.
I'll go ahead and call for that. Mr. Faulkner, thank you for your presentation. We will now open the public portion of the hearing for the matter of the proposed amendments to chapters 2, 4, 5, and 11 of the Tupelo Development Code to provide definitions and zoning classifications for brew pubs, microbreweries, liquor stores, and convenience stores
hold,
with fuel service.
I need to stop you right there. We have only talked about residential.
Understood.
So how can we open up the public portion if we have not done the same thing we just did for residential?
We certainly can, Leslie.
Am I right?
We just need to have a public hearing. If anyone has questions from the public to discuss the proposed changes, we can certainly do that. The committee's already reviewed it and discussed it, and then we'll have further discussion at the next meeting. We
At
can
the
open it
public-
up, but we just need for the record to clarify that the public hearing was held tonight for those chapters. And then if the committee would like to comment during the public hearing, set portion, that we will further discuss those matters.
Okay.
items
We
at
had
the
a,
next
we had a
meeting.
Okay.
public work session on it where we discussed it and
Okay.
made
Go
some.
ahead.
And so
I'm
we're
sorry.
here if anybody would like to comment on it, and I think we can do that. Is there anybody here who would like to speak on the matters of the overlay district and the amendments to the Tupelo Code, chapters 2, 4, 5, and 11? If anybody would like to speak on the matter tonight. Okay, hearing none. Any comments by members of the committee? Anything further?
Yes.
Yes, ma'am. Go ahead.
God love me. So for the beer thing, wait a minute, was it beer? No, this was the business district for Park Hill. I got confused over the use regulations, when we think about it being a business district. So I was looking through that, and let's see. Along the noted corridor under MDR and MUR, you cannot have the following. And please tell me if I was correct. So on those business districts, you cannot have a convenience store with fuel sales, a drugstore or pharmacy, engine repair or vehicle service, financial establishment, or a restaurant with a drive-through.
So let me, for the record, the business district is not up for debate. The business district is already incorporated, and that was included as a mistake in the packet. The only thing being considered is the Park Hill overlay, residential overlay.
Oh,
Yeah,
okay.
The business overlay was a done deal. It
Yes,
was just
already.
included by mistake.
Yeah,
Okay.
it was adopted in 23, I believe, or 24.
Okay. All right. Well, that is of concern.
It is, and I'm not prepared to answer that question
Okay.
tonight, so we will certainly.
All right.
get
It's
you
in
that.
that email that I sent out.
I
'Cause
think we discussed it in the work session, not necessarily specifically regarding Park Hill.
Okay, I didn't realize that that was not in there. All right. Okay.
All right, do we have a motion?
Okay,
Do we have a motion on TA 25-01?
so I'll make a motion that we request the city to go back and revise the code language to include changes to the review procedures, the carport on the side and rear or in a closed garage, roof language requirements, 10-day review, foundation, minimums and maximums.
I second that.
All right, all in favor? The matter is approved as stated in the motion.
Okay.
All right.
All right, I believe that that concludes the business of the committee for this evening. Do I have a motion?
We
Set up-
Oh, I'm sorry.
We do need, our regularly scheduled August meeting will be held August 4th, 6 PM in the council chambers.
Thank you.
And would request a work session on the 28th of July at 5:15 PM, third floor, conference room, City Hall.
Last page.
All right. Our next meeting will be August 4 at 6 PM here with a work session on July 28th, 5:15 PM on the third floor of City Hall. Having said that, do we have a motion?
I make a motion, we adjourn.
All in, do we have a second?
Second.
There,
All
Pam
in
seconds.
favor?
Yo.
The ayes have it.
Thank you all.
Good night,
Thank
everybody.
you,
Good work.
Thank
Good
you,
work
Leslie.
session, guys.
thank you. Thank you guys for being understanding.
Oh, well,
It is
thank you. I
important.
appreciate that. You know, he really should be coming to this committee to get his little parcel rezoned.
Yeah.
Oh, really? Okay.
And he probably ought to be reaching out to Mr. Pettit, I believe. He
Well,
may
like
have an
Sharon
interested
Hills
buyer.
doesn't have one anymore.